Okay. State, how are you guys looking?
I believe we'll be. Let me check. We are ready to present. Yeah, officer, you can take a seat if you want. Yeah, just right. Yeah. We're just waiting on defense now.
Okay.
What's up?
Just so I have this, just so I have this ready to go. Is it going to be
We'll reflect the statement once we present it before the court, not outside of proceedings. No. You don't talk. You don't talk. You don't talk. Not yet. No.
uh,
We're
can I
not
get the
really
charges for the filing?
sure. It is going to be it's going to be ATM fraud. It's a probable cause hearing for ATM fraud.
ATM fraud is that the only charge?
Yes.
And then what and then do you know if a video exists or no?
There is no video, but it's probable cause, so there shouldn't be a need.
It's fine.
The officer's testimony should suffice.
Yeah, no, that's fine. Just
Also, if you want to bring Joseph up, I think he wants to try and stream this.
oh yeah, sure.
Yeah. And it's just a probable cause hearing. This shouldn't need too much consultation. Whew.
The officer sit with you at council table or no? Is this thing on? Oh yes, it is. Okay. Oh, I can't hear anybody. Okay.
Okay.
All right, ready?
Yeah, I'm ready on my end.
All right, let's do it. All right, let's bring him out.
Yeah, we can bring him out.
All right, here we go. No, detainment timer is indefinitely paused for PC hearing, so don't worry about it. All right, pull him out. All right. We're doing probable cause for State of Ridgeway versus Emergency 30-30-30. All right, let's quickly do appearances.
I'm not Rummy on behalf of the state.
Then tactical Rummy on behalf of the defendant.
All right, thank you. All right, let's see. What do we have before us today? Do you have the charges ready to go? State.
Yeah, we are seeking probable cause hearing for one count of ATM fraud.
Okay.
Once
Alright.
you're ready for that report, let me turn off my Roblox audio 1 sec. We can present it right now.
All right, I'll take that report whenever you're ready.
Okay. Would you mind sitting the defendant down, please?
Yes. Please do that.
Searched. There's no need for. Yeah. Okay. 1 moment. Officer responded to a report of an ATM robbery in progress at Palmer Gas. Upon arrival, the officer observed the suspect actively engaged in accessing the ATM in a manner consistent with forced entry. The officer detained the suspect, and during a lawful search, indicated that he was going to make an arrest and discovered cash on this person. The recovered currency was then, of course, identified as traceable ATM cash. Given the officer's direct observation, the suspect's possession of traceable cash, and the circumstances of the incident, there's probable cause to believe that the aforementioned offense has been committed.
Okay. All right. Thank you, State. All right. So we're here on one count. That's violation of Ridgeway Criminal Code Section 4.10. Defines, quote, the act of tampering with an ATM or successfully stealing money from an ATM, close quote. It's a felony, punishable by up to 10 minutes of jail or an $800 fine. Okay. Defense, does your client understand their rights to remain silent? The right to the attorney and the charges and penalties that have to fit them?
Your Honor, I did not have time to advise my client of the right to remain silent, but otherwise they are aware of the right to secure counsel in this proceeding as ordained and adopted and held in Escondido versus Illinois.
Okay. All right. Thank you. All right. All right. Defense, you want to bring anything up in regards to officer statement? And if you're contesting?
We would like to contest probable cause. I do have a quick question for clarification if the state wouldn't mind to clarify something that was said in the statement.
Sure, go ahead.
So in this specific matter, did the officer directly observe the individual allegedly tampering with an ATM, or how was the sufficient cause based to justify a reasonable search of my client?
Yeah. So the officer observed the suspect actively engaged in accessing the ATM in a manner consistent with forced entry.
Okay, and then did the officer observe any monetary gain allegedly from this?
I mean, yes, as was reflected on the probable cause statement, he had traceable cash on him.
Okay. Your Honor, the U.S. Supreme Court has held that ignorance of the law is no excuse. However, within elements of fraud cases, there's typically required specific intent for acts of defrauding, but it is noted here within the Ridgeway Criminal Code that this specific offense does not articulate as to whether or not specific criminal intent is needed for the burden of meeting the charge of defrauding or any kind of fraud. Instead, rather, my client is being charged for tampering an ATM and allegedly stealing money. I would argue that the charged offense does not necessarily meet the elements as my client here argues that they were trying to repair the ATM.
What?
That is what my client said in custody. They were trying to repair the ATM, and then therefore there is no specific criminal intent asserted in the contention of the public defender's office.
Your Honor, may the state provide a response?
Please.
Whatever the intention may be, ATM fraud as defined by the Ridgeway Code, Section 410, is the act of tampering with an ATM or successfully stealing money from an ATM. We've met both of the requirements for the charge here. One, the tampering in itself. Even if you're going to try and assert a defense that you were trying to repair it, he's not an authorized person to be touching that machine or anything, or not touch. Sorry, he's not an authorized person to be tampering with that machine. So counsel has, even through their defense, recognized the first element required for the charge, and then of course the second one being the traceable cash, which was recovered on the scene.
So, State, just to be totally clear with you, the officer directly observed the defendant crouching down at the machine, attempting to fix, tamper, or whatever with.
That's what's on the PC report. He
Okay.
witnessed tampering with the machine that's consistent with signs of forced entry.
Okay. All right. I just wanted to make sure. Yeah, I mean, no way. I'm finding that they were trying to repair the machine. I'm finding probable causes to count one. Does either the state or the defense have anything they'd like to say as regards to bail?
I would like to add something, if I may, Your Honor.
Sure.
My
Hold on one second.
client. Oh, okay.
Bring it back to the lectern. Hold on. Okay. There we go. Thank you. Sorry about that. Please continue.
I would like the court to take judicial notice of my client's current status as a tourist. They are not an ordinary and regular citizen of the state of Ridgeway. They are newer to this game and potentially its mechanics, and I ask for that to be considered and taken judicial notice of with regard to bail and sentencing.
All right. All right. That's heard. State anything?
We would seek the whatever penalty the court finds appropriate. It's not that big of a deal.
Okay. The state does raise a good point, and as I'm viewing their record here, they
Also,
they
I
do
think
not
that
have.
it'd probably be good to book him right now, and you can deliver your I think he's got to go soon.
Yeah. Okay. I'm ordering the officer to fine him $800.
Okay.
So you just use the citation tool. I'm finding that
Before
yes.
$800 isn't too bad of a after committing robbery. That's pretty easy if you ask me.
Yeah. What's up, Suga?
We got people in lockup.
We do.
Yeah, we got quite a bit.
Oh. Okay.
Yeah, he
Yes,
has to
please.
leave.
And just use the citation for ATM fraud.
His issue. He has to go.
All right. I'm finding probable causes to count one. You're fined $800. Next case.
Yeah, next case. And please help him quickly because we don't want his guardian getting mad at him.
All right. Who's the next defendant and who's the officer for it?
Could you please DM me your PC statement?
Mhm. Okay. Go to man 0.
What's the problem? Oh my god, this guy, look at his shirt.
Oh. Oh
You know who
my.
that- You know who that is? Still
Oh.
waiting for that PC statement to be
Okay. Defense, do you need to talk to your client at all, or are you good?
I'll go ahead and talk to him if that's okay.
Okay. All right. What do you call it? Officer, can you take him back to lockup with Mr. Rummy?
I will be ready to present the probable cause in about 60 seconds.
All right, heard. Let's see. How many people are in lockup right now? Oh, just 10. Okay.
Suck. Sibley, I'm applying to you, so we make sure this reflects what happened. Also, DM me the charges you want to do, Sibley. And please, yeah. Confirm. Okay, I think we have enough on our end to find probable cause, so if Rummy 2 is good to go,
Okay. What are the charges gonna be?
they're going to be obstructive noise pollution and evasion.
Okay. Normal, I assume.
Yeah.
Okay.
I just need the officer to confirm that the probable cause statement that I'm going to present is right. Still waiting for him to.
All right.
Uh,
Ready to go, counsel?
Mr. Sibley, if you're going to send a message.
Still trying to confer with him. He's using Whisper. The officer kept him detained.
Okay.
Mr. Sibley, you can let him go now. Keep him in cuffs.
Yeah, you don't have to hold on to him. He's not gonna run. If he does run, that'd make his day a lot worse.
Okay, we're ready to present our PC statement. Sibley, you can sit down. Your Honor, are you ready?
As soon as the defense was ready. Okay.
You know we had Whisper in Ridgeway. Whisper tactical. Wait, test. Oh,
All right, we're ready to go.
okay.
All right, let's sit. All right, Mr. Rummy.
Off-
So, all right, let's hear it.
Officer observed the suspect repeatedly honking their vehicle's horn in a manner that constituted excessive noise pollution outside the Palmer County Hall. The officer issued multiple verbal warnings for the suspect to cease, but they refused to comply. Upon attempting to place the suspect under arrest for excessive noise pollution, the suspect fled in their vehicle. The officer activated emergency lights and sirens, initiating a pursuit. Despite these clear signals to stop, the suspect continued to evade law enforcement. A few minutes into pursuit, the suspect crashed in their vehicle into a pole. The officer then removed the suspect from the vehicle and took them into custody. Based on the suspect's actions, there is probable cause to believe they committed the offenses of obstructive noise pollution, failure to comply with lawful order, actually, and of course, evasion, or I would even go as far to say felony evasion.
Okay. Are you going to be charging him with felony evasion?
Yeah.
Okay. All right, Hertz. Thank you. All right. So, obstructive noise pollution. The act of committing excessive noise pollution within earshot of any state legislative building or state court building where the respective body is convened, or at any other place where the state legislature or state court are convened when the person making noise is aware that the legislature or court is convened nearby. Misdemeanor punishable by a $1,000 fine or 15 minutes in jail. We're also doing failure to comply here, and that's going to be in violation of Ridgeway Criminal Code. Section 2.04, the act of disobeying a lawful order which is given by a peace officer prior. It's how did he die?
I'm assuming by a car bomb.
What?
Well, new life rule, right? So.
How did what? How did he die? What the heck?
He's gone. I guess that hearing's over. Next one.
Yeah, I guess the next case. I don't. How did he even die? What? That's weird.
You know, it'd be good to get some security in this courtroom.
Yeah,
So,
looks like so many
this is
cops on. Unfortunately,
the most dangerous room in all of Palmer.
that is weird. That's one way to get out of it.
Does this count as my Better Call Saul?
Yeah, there we go. Okay. All right. We got somebody here.
Oh my god.
All right,
This
let's
guy
go.
straight out of the Napoleonic genre.
Okay. All right. Taking the lockup, please, with Mr. Rummy.
So same protocol as last time. Send me your PC statement, and I'll send one for presenting to the court so you can verify it's accurate.
What do you call it? I guess while we're waiting for him to do that, I will recognize some members of the audience. We have Mr. Ronald Download, and we have Mr. Papa Daves. Greetings to you both for coming on. Appreciate it as always. For the guys to interact with the with the court system, it's always appreciated.
All right, I believe we're ready for our probable cause statement.
Okay. All right, that's only one. We also have members of the media, including Mr. Timbo Walk, Joseph Richmond, I believe Bob the Joe, who's currently a bar applicant, I believe. That's Sniper All Star. Thank you for coming, Sniper. Zero Gauge, faithful sheriff's deputy. Most appreciated. Silbley, who's arresting officer. Zuckerblatt, Faceless Thinking. He's been a litigant before the court before. And Billroad Man, I don't think we've interacted with you, Billroad Man, but appreciate you coming nonetheless. We always appreciate when members of the community interact with our legal system. It's always a pleasure to have you all here.
We got too many people in bucket.
Oh gosh. Okay. How big is the?
Cases.
We do. There's only one in lockup.
Oh, there's only one? Oh, I thought
Yeah.
we had like 3 there.
There's only one in lockup.
You can get back to work, Soak, if you want to go arrest more people.
Yeah.
I'll handle it from here. Okay, Choppy.
Okay. All right. Let's grab them out of lockups. Someone has to take them out. I can't take them out.
No
Yeah, we could do an expungement, Coso. We could do an expungement. If you go to the courthouse front desk, if you get $125 on hand, and you file it at the front desk, we can hear it now. Okay, that sounds good. All right, Mr. Marshall. All right, State. Let's go ahead and hear it.
Mirandize him first. Just advise him of his rights, or his counsel.
You do that. I don't know. It doesn't really matter.
In that case, officer responded to a report of an ATM robbery in progress at Blocksmart in Ridgeway County. Upon arrival, the officer observed the suspect actively engaged in accessing the ATM in a manner consistent with forced entry. The officer detained the suspect after the suspect attempted to flee and initiated a lawful search, which revealed cash on their person, traceable cash. The recovered currency was later identified, of course, as mentioned, as traceable cash, and based on the officer's observations, the suspect's possession of this cash, and the circumstances of the incident, there is probable cause to believe that the suspect committed the offense of ATM fraud.
Okay, is that the only charge, State?
We would like to add, due to the suspect evading from the officer, just to add some clarification to my PC statement, the officer did tell when the officer approached the suspect immediately reacted by fleeing. If you need case law, I would be happy to find it, but I do believe it is consistently been held in the courts that when someone is in the process of committing a crime and they flee from a police officer immediately upon seeing them, that is consistent behavior for probable cause for evasion as well. Due to the process, as long as we can first establish that there's probable cause for the ATM. Oh, one sec. There goes Arthur again.
You're kidding, right? Did our defendant just die?
Yeah,
He
Oh
sure
my-
did.
he sure did. Another new life.
Oh my gosh.
We really need to like start mod locking these court proceedings.
All the doors are locked. Who let the guy with the gun?
I hope you realize that. Like, they have
There's
not.
there's another guy with a gun right here.
I just want to say that I'm 1-2 right now. I'm ratio.
Police. Download. It's new life rule there, right?
Sorry, what's the other one?
It's gonna be. I mean, I'm not an officer, so I can't really like write a PC statement for it. So
Sure. Actually, Timbo, that'd be great if you can.
Tim, if you can make sure that law enforcement is aware that we're doing PC, that'd be good.
Yeah,
Oh, I
that
think we
too.
got another one coming in.
Okay. Oh yeah, here. There you go. Oop.
Yo, Dave, you should make it so that the DOJ can access the courtroom doors. Just a nice piece of.
I don't know about that.
I think it'd be a great idea. Just saying.
Oh, we need to lock the DOJ in here or keep them out. I
Yeah,
filed
the courts need their way to ignore the Department of Justice.
Yes. Okay, we got one coming, and then we're gonna do the expungement for Kozo J3 BCA.
Oh, can you run my record real quick? See when I got those citations?
Yeah, I can do that. You got one citation on. Oh, both of them are on the 25th of January.
Has it been 7 days?
It will be. Oh, yeah, it has been 7 days. Yeah.
Oh, flower. Oh, we got another shooting outside. Hey, Rummy, you think you could open the door for me real quick?
Here, I can do this one.
I'll be right back.
Thanks. Are the rumors true that we're going to be getting a courthouse in Milton in phase 2?
What is this phase 2 is everyone's talking about?
That's what Syntax told everyone.
I don't know. I'm not Syntax. I know the Capitol's meant to basically be the county courthouse, but on steroids, so it would inherently have a chamber, but it's supposed to be the Supreme Court, not the county court or state court. So y'all would still be here.
Interesting.
You list out the charges for me? The citation, sorry.
Uh,
They auto come up.
It's so weird because Syntax told us that we were getting a separate courthouse building.
a separate building. There's no space in Milton for a whole separate building.
Huh. I thought it was the one at the end of Racine Junction, that like giant justice looking building.
Towards the port, towards Palmer, at the end of that junction.
Yeah, the I thought it was
Yeah,
like
that spans like 2 blocks.
yeah.
Yeah, that's Grand Central, brother.
Oh, okay. So I got. Yeah, we could do these next. Yeah. So yeah. All right, we're good to go. Let's take them out. All right, ready to hear the statement.
One
Mr.
moment. Sorry. Okay.
All right, whenever you're ready, state.
All right. Officer observed the suspect operating a vehicle in a reckless manner. The officer attempted to initiate a traffic stop, but the suspect failed to comply. and instead led law enforcement on a short vehicular pursuit. During the pursuit, the suspect struck the officer with their vehicle, resulting in the explosion of a car while the officer was being ragdolled from being run over. The impact, of course, sorry. Following the explosion, park rangers were able to detain the suspect and later transferred them back into the custody of the officer. Based on the suspect's reckless actions, failure to comply with law enforcement, and resulting fatality, there is a probable cause to believe that the suspect committed multiple offenses, including. Do we have the vehicular manslaughter added or no? Or would it just be first degree murder? Sorry. First degree murder and felony evasion.
Okay. All right. Thank you. State. All right. Defendants. What do we got here? We got one count of murder in the first degree. It's a big one. It's a really big one right there. It's going to be in violation of Criminal Code 3.09. The act of committing murder in the course of committing or attempting to commit kidnapping, burglary, robbery, arson, obstruction, or retaliation, or committing murder of a peace officer or civil department employee discharging lawful and official duty with the knowledge of that person being a peace officer or civil department employee, or of committing murder with the malice aid for that. It's a felony punishable by up to 30 minutes in jail. Okay. Does defendant understand the rights and charges and penalties? Oh, he's in the VC. Wonderful. Okay. In that case, defense, do you have anything you'd like to say, and are you contesting?
I believe my client would like to contest the probable cause.
Okay, for both counts or just one?
Let me double check.
Okay, it's gonna be one count of murder in the first degree and one count of felony evasion. Let's see.
Okay, yeah, both charges.
Okay.
Okay, after this, sorry, I was making sure he wasn't a super counsel in the hearing. Um, so regarding the first charge of first degree murder, I did confer with my client back in holding, and he had stated that he did not remember committing this offense, which we were contesting would kind of go against that requirement that the knowledge of the person being a peace officer or civil department employee, considering that the victim was not even known to my client. That would go towards the specific criminal intent that is required for first degree murder, and that is not required for other charges. So that would be our contention there. Regarding the evasion, my client would like to contend that he had his audio disabled and was unaware that he was in or being pursued by law enforcement. But regarding that first charge, we'd like to emphasize that my client was not aware of the identity of the victim, and as such, the charge alleged does not meet the burden of probable cause as the element to satisfy first degree murder is not satisfied. Thank you.
Okay. Thank you, State.
Yeah. So state believes that the argument that Mr. Tactical Rummy is making, opposing counsel is making, would be an argument that the court could potentially entertain, but it'd be entertaining it in the domain of beyond a reasonable doubt, not probable cause. As we all know, the burden for probable cause is much lower, as per is the policy of the officer's department. The officer was, of course, in a clearly identifiable uniform. So he, of course, is a identifiable law enforcement officer. The probable cause in that sense for intent, I believe, is established, just due to the lower burden too. The rest would, of course, have to be examined at trial. As for the attempt to apply some sort of affirmative defense based on the fact that he could not hear the sirens, well, number one, I'd hint towards the injury the officer suffered in the process, and number two, I'd further hint at the fact that it's not really an excuse. Officers don't only use sirens, but they also use sorry, they also use lights to identify themselves when they are pulling someone over. So I don't believe that the defense opposing counsel tried to raise there is really valid at all.
Okay. Was the death of the officer caused by the the wanton recklessness of the defendant's evasion? Is that what the state's saying?
The death was caused by the fatal injury of the officer being sorry of the officer being of course next to the exploding car, the car which sustained damage as a result of the suspect's actions, as described in the PC report.
Okay. All right. So I'm gonna go. Okay. So that felony evasion, I'm gonna find probable cause for it. I think that one is pretty clear to me. For the murder in the first degree, I don't know if we can say that I don't know if actually state I could use your help on this of the intentional and knowingly causing his death with the car.
Your Honor,
One
may I
moment.
point something out here?
Sure.
So, for the element of first degree murder to be satisfied, it would require my client to knowingly be aware of the status of the victim, and in this specific case, it is vicarious liability, which I acknowledge is a civil principle, but it is striking a vehicle which then subsequently caused the death.
Yeah. That's the part that I'm thinking about here because sure he can if he's wearing clearly displayed uniform with patches on his shoulders, then I can understand why that he know that he's an employee. However, if he was caused if the death was caused by his actions in the pursuit and he wasn't necessarily intentionally and knowingly causing the death of him, and that rather he was doing it because of his reckless actions, I don't think that that's murder.
One second, Your Honor. I'm finding the case law on this. If I would be willing to contest that point, but I'll need at least 5 to 6 minutes.
Okay, because it says in the criminal code, it says the act of committing murder is the act of intentionally or knowingly causing the death of an individual. If he struck him with a car, he didn't know it was going to cause his death, and if he didn't have a reasonable way to know that, then how could he be intentionally or knowingly doing that? You know. Actually, or of causing with intent serious bodily injury. Did the state? I can't remember in the RPC statement. Is it the state's point that he intentionally struck him with the car, or that he recklessly struck him with the car? Like he didn't intend to, but he did anyways.
Well, as it was in the commission of a crime, right? I'd say it was intentional. Or at least I'd say that the court could find probable cause towards the intentionality. As I originally stated, the burden here is not beyond a reasonable doubt. The burden here is probable cause.
Yeah. Okay. Because
But it,
I looking at the second part here, it says of causing with intent serious bodily injury. That I mean, if he intentionally struck him with the car and he died, then that's still murder. So that's what I'm trying to figure out here is the intent factor.
I mean, the statute goes as far as to say, or committing murder with malice aforethought. So, important to keep in mind.
Mm-hmm. Okay, can we have some order in the gallery, please? Thank you.
I just want to add from the defendant's view here, my client. So regarding that, we would ask that the court take into consideration, Illinois versus Gates, which does call for a totality of the circumstance. If you're finding probable cause for my client's evasion, allegedly, then I don't think it would be prudent to say that somebody giving flight would then necessarily form the intention to take a life of an officer, if that makes sense. I think that this is something that was a consequence but not intentional and specific enough to demand charging with first degree homicide or first degree murder.
One
Yeah.
moment, Your Honor.
Yeah, I mean, oh my
Oh.
gosh.
Well, this is about to become irrelevant. Someone with the fire department out here.
I want somebody to clip that and send it to me, please. I want him charged. I want that man charged with arson.
I'm pretty sure that was an alt, but I'll see what we can do. Yeah, Your Honor, look, I think it's fair to say that intentionality can be established here from a probable cause perspective due to the fact that he was fleeing, and we can establish clear incentive at least. We can establish a clear incentive for why he would want to disable or murder the officer. So I'd still say that we have a first degree murder beyond a reasonable doubt. I mean, that would have to be revealed at trial, of course. Maybe not right now. But as for the burden of probable cause, I do believe it's met, at least to make an arrest.
See, Gates' doctrine, though, is for the totality of the circumstance, specifically for the burden of probable cause. And within this specific action, the court is left with a dilemma to decide whether or not the specific elements of the charged offense are truly to the intention of my client. And I believe that it's difficult here, having sat in the other seat and sitting in my seat, in the regard that I don't believe intent can be established. I mean, we're talking about specific criminal intent, not general criminal intent. And just as the state wants to bring up the varying degrees of burdens of proof from reasonable suspicion to beyond a reasonable doubt, it's equally as important to remember that we have varying elements of offenses to be charged with regard to an offense requiring specific or general criminal intent. And it has been long held that a charge of first degree murder requires specific criminal intent, which I would contend cannot be established, although the assumption here is that it is established by striking a vehicle and then leading to that loss of life. The specific criminal intent would be my client running right over that officer, charging at that officer, trying to take the life of that officer. That the state is contesting would be general criminal intent, which is not proper for the charge of first degree murder. Thank you.
Yeah, I mean, the probable cause arrest needs to require at least some evidence supporting each element of an offense. I mean, that's Paul versus just DC. We got Wright versus City of Philadelphia. It's been long held that they need to show some kind of elements of each thing, and I don't know if I think voluntary manslaughter, sure, involuntary manslaughter, definitely. I mean, I mean, clearly his behavior was reckless, absolutely, and that he ignored a known or obvious risk by fleeing from the cops. That was not smart of him. But I don't know if that's. It's very hard for me to say yes to a murder in the first degree for being stupid, basically. Like, I mean, I don't.
In
I don't
that
know.
case, Your Honor, we would seek to reintroduce an amended charge list.
Okay, what's the
That's-
amendment?
One moment. Run this through. We'd add voluntary manslaughter in there for sure. We'd amend it to remove the first degree murder charge, amending it to a disenhancement of voluntary manslaughter.
Okay. Any objection from the defense? Defense?
Sorry, Your Honor, I'm conferring with my client.
Okay. Moving it from first degree murder to voluntary manslaughter.
Sorry, did you say involuntary or voluntary?
Voluntary, I believe.
Involuntary. Okay.
No. Other way around. Voluntary.
Oh, okay.
Voluntary manslaughter would it's still a felony, but it brings down the jail time by 10 minutes.
Okay, Your Honor, we would like to contest.
Contest the voluntary?
Yes, that is correct.
Okay. All right. Let's hear it.
So, voluntary manslaughter, as defined in Criminal Code Section 3.07, it is the act of causing death of an individual while in the heat of passion. The state here, I have not received a probable cause statement to expand on the heat of passion, which is why my client is interested in contesting that the manslaughter was rather involuntary.
State?
Yeah, I believe the probable cause statement accurately reflects that the suspect was already engaged in criminal activity, specifically related to operating the vehicle in a reckless manner. And then, of course, subsequently being a part of a vehicular pursuit. That was all in the original probable cause statement. So I believe that, of course, correlates with the fulfillment to demonstrate that the individual was in a heat of passion. I mean, we're talking about criminal behavior associated with this. So I do believe it more than sufficiently builds up.
May I respond, Your Honor, now that I
Sure.
have clarification?
Yes.
So, in U.S. versus Browner, the Fifth Circuit defined heat of passion as a passion of fear or rage in which the defendant loses his normal self-control as a result of circumstances that would provoke such a passion in an ordinary person. In this case, there is no heat of passion. My client was not enraged. My client, as the court found probable cause for evasion, may have allegedly been engaging in the act of invasion, but there was no heat of passion. I don't understand why this charge is being charged. It's further away than the specificity of first degree murder and does not meet the element to be charged.
I do love the Fifth Circuit, so I'm looking at the case now. I see the quote you're pulling that from. Okay.
If we are going to litigate on this, I would ask that the court give us a 5-minute recess, at least so I can review the introduced case law and then, of course, contest it with my own.
Yeah, without objection, so ordered. Let's do the contempt then.
Take 1 second. I can't do both at the same time.
No, that's fine. I'm just gonna do the contempt myself. Can you take Lethal and Rummy back to lockup and bring the contempt guy out?
Okay.
You just let the contempt guy go. Oh dear gosh.
Could I have that case sent over to me too, please, Your Honor?
Yes. U.S. versus Browner from the Fifth Circuit. Who doesn't love the Fifth Circuit, huh? If you find Fourth Circuit case law, I'll listen to that one more though.
Just send that over to me. I hate the fact we can't fucking copy and paste from our own criminal code. This shit's annoying every time.
Yeah. Well, actually, Mr. Dave, is there any way to allow that or no? Okay. Okay. All right. This guy, hold him at the lectern, please. Mr. Ya says, I can't pronounce your name. You are ordered to show cause for one count of criminal contempt of court for your willful violations of this court's decorum and procedure by jumping around, overcoming the bar, and screaming during the middle of the proceedings. Is there anything you'd like to say as why you should not be held in criminal contempt of court? You were yelling in the courtroom. Okay, then why did you jump over the bar then? It was an accident? Okay. Why should you just run out? Okay. Thank you, Mr. Guys. I'm adjudicating you guilty of one count of contempt of court. I'm fining you $500. You'll be issued this fine through the court system. You have 1 hour to pay the fine at the front desk of either the courthouse or the government annex building. If you do not pay within 1 hour, you get a warrant for your arrest. And there's one count of direct criminal contempt of court. And this is going to be for $500. Thank you, Deputy. You can release him. You have 1 hour to pay the fine, sir.
Just saying, now you can copy.
Oh, thank you.
Thank you. Awesome, Don. Oh, I got one from the Fourth Circuit.
You did? Oh. I don't know. I have to go with my home turf.
Three from the Fourth Circuit, actually. This is going to be fun.
I have to go with my home turf here in the Great Commonwealth.
Great Commonwealth. The Great Commonwealth.
Okay. Is there anybody else in lockup?
All right, Your Honor, we're ready.
Okay. We'll just wait for the defense to come back.
Always a good case when it's a Rummy v. Rummy. These are the legal nerds in the room.
Hey, at least we can actually fight each other because the last time I was a PD, like I would win all of these. So I gotta give props to you. Like we're actually challenging each other here.
Absolutely. All right, let's take him. Let's bring him back. We're coming back into order. This is going to be State v. What's this guy's name? This is a lethal activity. We are coming back. The court has already established probable cause for one count of felony evasion. We are now contesting probable cause for voluntary manslaughter. All right, State, you're up.
All right, Your Honor. So our goal here, of course, is to establish probable cause for the voluntary manslaughter, right? So voluntary manslaughter is defined as the unlawful killing of another in the sudden heat of passion.
Sorry, can you speak for 1 minute? Okay, this guy, Mr. Yehaz. I am finding you in one count of direct criminal contempt of court. You are remanded to the county jail for 15 minutes. Is there any or you have anything you'd like to say before I enter that order? Okay, remand him. Thank you.
Okay, should I'll pick it up from the beginning, Your Honor.
Please.
So we're here to establish a probable cause for voluntary manslaughter. Okay. So
Okay.
when looking at it from the lens of this case, I think it's first important to recognize that voluntary manslaughter in this case is defined as the unlawful killing of another human being while being in the sudden heat of passion, provoked by sufficient legal provocation. What do I mean by this? Well, there's actually multiple well-established principles, which I'm about to explain, specifically in the Fourth Circuit, in cases such as Martin v. Wilson and the U.S. versus Albert Alexander Tisdale. We'll provide citations at the end of my statement. For example, in Martin v. Wilson, the court articulated that the heat of passion must disturb the ability of an ordinary, reasonable person to properly reason, creating an uncontrollable impulse to do violence. Similarly, Your Honor, in Tisdale, the court emphasized that voluntary manslaughter requires a killing upon a quarrel or a heat of passion, excluding malice afterthought. In the present case, right, the defendant was engaged in a high-stress vehicular pursuit before the incident. This pursuit, coupled with the immediate circumstances, could have more than reasonably provoked an uncontrollable impulse to do violence, thereby meeting the criteria for heat of passion. Now, the defense argues that the defendant acted in response to adequate provocation through their citation of the United States versus Browner. However, as established in sorry, I cannot pronounce this name, so just bear with me. As established in Fred Cornaharns v. Parker Evott, the provocation must be such that it disturbs reasons, and renders the mind incapable of cool reflection. The defense must demonstrate that the provocation was adequate and that the defendant's actions were not deliberate or premeditated. That's all I have to say, Your Honor. If you need the case citations, I will be happy to provide right now.
Okay. Could I check the Marion v. Wilson one?
Yep. I'll pull that up for you right now.
Okay. While you're doing that, defense.
Yeah, Your Honor. So regarding adequate provocation, in U.S. versus Browner, again, the definition with a passion of fear or rage in which the defendant loses his normal self-control as a result of circumstances that would provoke such a passion in an ordinary person. And then again, which that was in the Fifth Circuit, but again in the U.S. versus Vizianaz, which is from the 10th Circuit, it was held that in order to satisfy an element of malice afterthought in a murder prosecution, the government must prove the absence of heat of passion. So we've worked our way down, essentially, to where the state believes that there is a heat of passion. I want to use this from a common sense standpoint, Your Honor. My client was being pursued by an officer, and that officer was on foot. My client is operating approximately 2-ton motor vehicle. That's about the average tonnage of a vehicle. So he's operating a 2-ton machine, a giant machine, and this officer is on foot, and he strikes another vehicle, which allegedly, leads to the death of that officer. What is there here to say that there is heat of passion? Why would my client here have fear or rage? If my client is allegedly giving egress, as the state contends and as the court has found through probable cause, then subsequently what would form a heat of passion? And I would like to remind the court, per the state's previous remarks, that the burden of proof for probable cause isn't on the defendant; it is on the state to prove. And within this matter, I believe we're once again at the crossroad where the state is picking and plucking charges to attach to my defendant when there's very clearly one that matches it. And so we're having to litigate this in open court through a probable cause hearing when in reality, the state is trying to grab at felonies. Thank you.
Mhm. All right, state, last thing.
Two things, Your Honor. First one, I would like to exchange with opposing counsel real quick. When you reference the new introduction of case law you brought in, or the new introduction of precedent, sorry, you referenced the what the court wanted the state to establish, right? Was that for probable cause, or was that for beyond a reasonable doubt?
That was as an element to charge the offense, I believe, which is a basic, basic thing to establish.
And yeah, you didn't clarify that in your statement, so just making
Yeah.
sure. Second thing, Your Honor, listen. It's cut and clear, bright as day. The evidence clearly supports finding probable cause for voluntary manslaughter. The circumstances of the vehicular pursuit and the subsequent events all serve as sufficient provocation, which would lead to the high stress, which would lead, of course, to the qualifier, which is the heat of passion. Well, sorry about that. All the elements are there for probable cause. As I said, beyond a reasonable doubt, it would have to be seen at trial. But for probable cause, I think it's quite clear. There's all the elements there. We haven't even considered the fact that there's the dead officer, of course, but then there's the whole sequence of events. The courts in the 4th District upholding similar instances of probable cause. So the state has nothing else to say on the matter. We'll wait for your ruling.
Okay. Yeah. So I don't know. When I look at heat of passion, I'm of the belief that it is it's response to something that would cause an otherwise reasonable person to lose their sense of self-control, right? That's my opinion of it. So is a police chase something in the stress of a police chase sufficient provocation? I don't know.
I mean, I think it's important to note that this was a vehicular pursuit, right? This wasn't he didn't pull over and then the incident occurred. No, this was a buildup of events. So a vehicular chase that you're actively engaged in when you're fleeing from the police, I'd say so. I believe so, Your Honor.
I mean,
But
I'm looking at his record right now, and I'm seeing. I mean, he got arrested 2 days ago for vehicular assault. He has another one for reckless driving, another vehicular assault, possession of a stolen vehicle, 3 vehicular assaults, 4, 5 vehicular assaults, 6 government vehicle theft. I mean, this guy, he has a long rap sheet of these offenses. I don't know. I don't know why the state in charge of vehicular assault of all things, but okay. And then citations like reckless driving, failure to yield, illegal parking, reckless driving again. Yeah, I mean, he has. I don't know. He has a lot of offenses for crimes he commits in his 2,000-pound war machine. But so I think in that sort of sense, he's become comfortable with that. And I don't know if this is, anything other than an ordinary Tuesday for him. Being in a police chase, because he also has, let's see, felony evasion 1, 2, 3 counts. Yeah, I don't know. I mean,
and again, if I may, Your Honor, from a common sense standpoint, my client is operating approximately a 2-ton vehicle, and an officer is on foot, which is what leads to that officer being subsequently blown up by that vehicle explosion, allegedly. I can't find a reason, and nor can my client, to demonstrate fear. My client is operating a motor vehicle. The officer is on foot. Sure, you can say the totality of the circumstances there. You're in a vehicle chase. You try to define that as heat of passion, but I don't really think that that a prudent person would say that somebody operating a vehicle is allegedly giving egress court finding probable cause for evasion would then be fearful. That's the part that I'm not understanding. Is the state on one hand is saying, oh, we're going to say that this vehicular pursuit
it's a regular Tuesday for this guy argument. I believe that courts have traditionally upheld that if someone is that people who flee from law enforcement are most likely doing it in fear of something, or else they wouldn't flee. In this case, of course, it was in fear of most likely going to prison, or being arrested, or being detained, or even taking your own argument is with all these previous arrests, fear of being taken to court, investigated, charged, and then receiving multiple more sentencing enhancements. There's a plethora of differences there. As for intent, I think intent is clearly established from a probable cause perspective, because we have to going back to the basics, the sequence of events. The suspect was engaged in the vehicular pursuit. He started to, of course, flee from the officer, and in the process of that pursuit, I think it was very clear that the suspect wanted to disable the officer from pursuing him, and in that sense committed voluntary manslaughter. I do believe there's enough probable cause to establish that fact, at least.
I don't know. I like the fifth. I think the Fifth Circuit's definition makes more sense to me. Fear or rage in which the defendant loses his normal self-control as a result of circumstances that would provoke such a passion in an ordinary person. I mean, yeah, I can see that actually. I mean, if he doesn't want to be taken back to jail and he's running from the cops, maybe he turns his car a little bit left, so he hits this guy instead of going straight.
I would like to object to the fact that my client, the state's not alleging that he's struck an officer. He struck another vehicle, which then subsequently led to this, Your Honor.
Oh, okay. Well, in that case,
One second. In the probable cause statement, the crash.
can someone sit this officer down? What is he doing?
In the probable cause statement, we do explicitly state during the pursuit, the suspect struck an officer with their vehicle, resulting in fatal injury.
Right.
After the explosion goes off. Sorry.
But I thought that this was related to the subsequent explosion. An explosion caused the death.
I misread. I didn't misread previously. I just misread right now. My apologies. Let me clarify. The officer was struck by the suspect's vehicle. The officer ragdolled, and then while the officer was ragdolled, the vehicle exploded, killing the officer.
Oh, I see. Okay, yeah, no, then. No. It should have been involuntary. I'm not doing probable cause for voluntary. He is finding probable cause for felony evasion though, so he's still getting booked either way. But yeah, no, that makes sense. Okay. Conditions of bail, anything?
Nothing else. We're not gonna. I mean, I'm not the type of person to. We already downgraded the charge. Sorry, we downgraded.
No, fair enough.
I'm not
Okay.
gonna do it
All right. Defendant, anything you want to bring up?
Sorry, I will say, considering there was a death involved in the incident, the state would seek the maximum penalty.
Okay. Defense, anything you want to bring up for the felony evasion?
I would just say, given the contention and the discussion that we've had with criminal intent, that the court would take judicial notice in this matter that although probable cause is met, the intent and the intention behind the defendant's actions, the actions of my client.
Okay, well, duly noted. I mean, I'm inclined to agree with the state. He was fleeing from the cops, pretty plain and simple. So, I think, given that he was doing that and the death was caused, I mean, even though it wasn't the correct charge for it, I believe that should still be taken into account for the sentencing. All right, I'm issuing the following sentence to direction. Probable cause is found on one count felony evasion. That's Richard Criminal Code Section 2.10. I'm ordering that he be remanded to the county jail for a period of 25 minutes. All right, you can take it back. All right, we have one quick expungement that we got to do, unless there's another guy in lockup. Is there? Oh, yes, there is. Okay, can we? All right, so let's do this one. So, while CPD Rummy is meeting with his client, we're going to hear Billy Bob Joe his expungement petition. So, if you could,
Judge, real quick, on that prior case, is my client getting any kind of time served credit for the amount he has been in custody already in the holding cell?
We'd object to that.
I'm gonna say no, because usually that's the amount of time you'd face anyways. So, sorry, sorry, but at least he doesn't. It's felony evasion. Okay, so why don't you talk to your client in lockup, and then Billy Bob Joe take a seat at the table that Mr. Saint is sitting on, and we're gonna do the expungement for you now. This is stock number okay, this is docket number RSC-EX-3624. The petitioner is seeking an expungement of one arrest dated June 27, 2023 for attempt to commit a crime. A search of the petitioner's record reveals that it is the only offense or citation on record. Pursuant to Title II of the Ridgeway State Code, a petition of under 9 records is classified as a Class 1 expungement, in which there's a mandatory 14-day waiting period, and the petitioner must demonstrate he has good standing in the community before such expungement may be granted. Mr. Billy Bob Joe, do you have anything you'd like to say for your good standing in the community? Your waiting period is met, but in the statement it says that you generally want to contribute to the group. Can you provide any more details on that? I can bring you up to the stage too if you raise your hand if you want to talk in BC instead of yeah, put him in lockup real quickly though, because we're doing this thing right now. All right, I'm bringing you up to the stage, Mr. Billy Bob Joe.
Thank you, Your Honor. I'll make this brief. Yes, I believe what I said was I have just recently submitted my bar exam, like you have said earlier. I am wanting to be in good standing with the community and hopefully serve the public defender's office, the state, with the Department of Justice, and or possibly work in the courts as judicial clerk and maybe make my way up to a position like you as a judge. With this expungement, I believe this will help set forth in motion my plan of working in this judicial system.
Okay, thank you. State, anything you want to say?
No contest.
No contest. I find the petitioner in good standing. I'm issuing an order granting the expungement of the one arrest.
Thank you, Your Honor.
Yep. 1 second here. Okay, let me know when it pops up on your screen. 3624.
You should have also gotten a new expungement in there, by the way, Arthur.
Okay. Oh, I see who this one's for.
Well, congratulations, you've gotten expungement
Okay,
for
awesome.
the record. Thank you very much, Your Honor.
Yep, thank you.
I'm gonna open this door out here.
Which store are you at? Oh, this one. Okay. There we go. Okay. I'm just gonna make some other notices on some of these expungements. Let's see. So there's an expungement petition submitted by Kozo J3BCA. Wrote a very in-depth statement that I believe shows that he would like to be in good standing, but unfortunately, the last arrest is on January 26th. Oh no, this 2024. Maybe we'll have to hear this one later. Let me check this record. No, never mind. He was arrested today at 3:42 p.m. So that's Mr. Kozo, you have to wait 28 days for the next time you can petition for an expungement since you got arrested today. So 28 days from now is going to be what, March 2nd? All right. So because the waiting period has not been met, I have to deny the petition. I'm very sorry. Okay. Is there anyone else in this courtroom that would like their?
I do have a petition pending, filing a new notice of appearance.
Oh, I see it
Okay.
here.
Pro se.
All right, Mr. Rummy. These two individuals. There are two individuals being held. Oh yeah, we got to do the contempts. Let's quickly do those. Can you bring out the first contempt? Okay, is this guy in the VC or no? Let me check.
Dummy dode, dumma deo.
You fucking weeb.
I'm not even a weeb, bro. Fuck up. That's
Okay,
on
Mr.
Instagram.
All right, stop. Okay, Ben, Mr. Ben CUH 2022. You're ordered to show cause on one count of direct criminal contempt of court for your conduct in these proceedings, including but not limited to jumping over the bar and talking when the court was in session. Is there any reason why you should not be held in criminal contempt of court? And what is that reason? Okay, I'm finding you in one count of direct criminal contempt of court. You're remanded to the county jail for 15 minutes. Put order of Judge Chen on the LOB, please. Thank you. Okay, the next contempt proceeding. All right, Mr. Yahaz, it's you again. You're ordered to show cause on one count of direct criminal contempt of court, including but not limited to screaming while the court is in possession, including saying, quote, Black Lives Matter with a fist emoji and jumping over the bar. Is there any reason why you should not be held in direct criminal contempt of court? How do you pronounce your name? You did it again. Why did you were just held in contempt of court for doing this exact same thing? Oh, okay. Much better. Thank you for that. Now, is there any reason why I should not hold you in direct criminal contempt of court? And what is that reason?
Oh my god.
Hey, can somebody clear the jury box, please? I'm not doing a peanut gallery in the jury box. Thank you. Hey, you have like 1 minute to tell me why you're not going to be held in, why you should not be held in contempt of court. I'm ordering you remanded. Tagged. Okay, book him, please. Thank you. I'm adjudicating you guilty of one count of direct criminal contempt of court. Please book him. You're remanded to the county jail for 15 minutes. Please put order of Judge Penn on the LOB. All right, next case. Whenever the Mr. Rummy and his client are ready to go, we're gonna hear his hearing.
Whoever's the officer for that case, please send me the PC statement. Thank you.
I think it's Chappie, if I'm not mistaken.
Is he in this call?
He is.
All right. Chappie, please DM me your probable cause statement.
And Judge Chin, we're ready to go. I do have to go after this one.
Okay, that's fine. We will do that then. All right, so we lost one of the night. Let's hear it.
All right, one
Bring him out
moment.
of lockup. There we go. All right. Hey, State, are you ready?
Yep.
Okay, let's hear it.
Officer observed the suspect approach the scene of an active officer-involved firefight. The suspect was not authorized to be at the scene and proceeded to unlawfully take evidence and remove boxes of police-issued ammunition. Shortly thereafter, officers detained and placed the suspect in handcuffs. Based on the suspect's actions, there is probable cause to believe that they committed the offense of, let me get the criminal code, one moment. Just to get the exact one. Unlawful possession of government-issued equipment.
Okay. Thank you. Is unlawful possession of government issued equipment the only charge?
Yes.
Okay. All right. Defined as any player who. Oh wait, no, that's the wrong charge. Unlawful possession of government issued equipment. The act of unlawfully possessing any government issue equipment in any off-duty civilian storage device, capacity, or other inventory not mentioned, which is not authorized by state law or relevant department policy. It's a felony. Punishable up to 20 minutes in jail. All right, Mr. Or rather, defendant. Does the defendant understand the charges that he is facing and his rights to remain silent, retain counsel, and the warnings and privileges he's granted under the Constitution?
He does. I've conferred also with my client about the nature of the charged offense being a felony and the sentencing time.
Okay, thank you. Are you contesting?
My client would not like to contest, but we asked for the court to take judicial notice that flight is not a factor in the case, and the defendant did not flee from law enforcement, and that evasion is not charged in companionship with the PGE charge.
Okay, so heard. So I am finding probable cause as to count one, unlawful possession of government issued equipment in violation of Virtual Criminal Code Section 5.08. Let me check his record. Let's see if he's a first time offender or not. Tainted Vanguard. Search records. Okay, so Tainted Vanguard. He has an arrest from yesterday for evasion and ATM fraud, unlawful possession of government equipment. Kind 1, 2, 3, unlawful possessions of government equipment, and he has no citations. Okay. All right, because this is a felony and he has prior records for the same offense, I'm inclined to impose jail time. I'm going to be assigning him to 15. Let's do because there was no flight and because he stole ammo rather than weapons. I'm going to say let's do 12 minutes in the county jail. And he seems to be cooperative and patient with our court today, so I do appreciate that. For all causes established as to count one, he is remanded to the county jail for a period of 12 minutes. All right, so I guess that's going to be it for our hearings for now. We're going to be doing a couple more expungements, but as for PC hearings, that's what we're done. Please take this guy and book him for 1 count of criminal contempt of court. Thank you. 15 minutes.
We got no other retainer counsel wants to pull up.
We can ask Walter if he wants to come, but he might be busy. Mr. Devgrow, would you like to be duty counsel? You are technically bar certified.
Hell no.
Okay.
Oh, he just dipped out of here too. I can appoint him, Judge, a special assistant public defender if you'd like.
Wait, just give it to whoever Snipes my all-star is. He's dressed as me. He can be my representative. He can be the... Oh, yeah. Damn, he's getting cuffed? Damn. Yeah, see, he's representative.
No.
So,
Yeah, book him, please. Book, Case will just send him away.
So he's in
Okay.
this VC.
Yes, you can go ahead.
That's wild. But he's not a user, so he's an alt.
Okay. All right. Is there any other duty counsel that would like to appear? I can't think of anyone else that's bar certified in this chat. Oh, the court is awarding Mr. Tactical Rummy, Chief Public Defender, a total of $1,500 for his services today. $1,500.
Gone into public defender. Get paid jack shit with DOJ.
$1,500 isn't a lot either, but it's something.
Bro, I have like 1,000 in the bank.
Okay. What else are we doing here? Is there any other duty counsel that would like to be paid for their services here? We'll pay you $300 a case.
Sniper is bar certified, I believe.
He is.
Yeah. We'd have to check it.
Okay.
He's
Let
on,
me check.
he's on the meme board for the political compass for Roblox lawyers. So, Sniper, are you certified in Ridgeway or only Clark? Come up here, verify your. Have Arthur verify your bar number, and we'll bring you up on stage.
Okay.
Sit down.
I did not know he was bar certified. I'm kind of surprised, actually. And I'm checking.
Out by the Attorney General right now.
Okay.
Over a completely unrelated
Book,
matter.
please book this guy again. This yay ass guy.
Looking for what?
Contempt of court. He's literally jumping for it. And ban him from answering. He's done. Sniper, I don't see you on the bar list. Oh, I do see you on. Wait, no, I don't see you on. No, there's no way David Racine is on the bar list, adding him to the roster right now. That can't be real. That can't be real. There's no way. There's no shot that no. No, I'm not recognizing this bar number. That is Lady Justice. No.
It's not your position. This
I'm
man
not
is
recognizing this fraudulently obtained bar certification.
clearly an authentic copy.
That is crazy. There's no way. God 100 is his bar certification number? No. You are not. I am not letting you represent clients if you haven't even practiced. If you have to get Lady Justice to give you a bar certification, that's kind of a problem. There's no way. Oh my gosh. I search up Sniper and I don't see anything, and then I search up All Star, and it's at the very bottom of the list. I see David Racine, and he's typing in attorney and class god. No,
Well, you know, he's on the database, Your Honor, so I don't know what to say.
Could Lady Justice of the State please verify the
The Lady Justice hereby verifies.
Okay, Mr. Sniper. I don't want to accept you as duty counsel, though. I think this is not a good idea. Okay, Sniper, I'm gonna. Okay, yeah, come up to the stage.
Hello.
Sniper, hi. Stand in front of the podium. Okay.
All
Do you
right.
solemnly swear or affirm that the testimony that you are about to give before me is the truth, the whole truth, and nothing but the truth?
Yes.
Okay. Are you seeking to appear today as duty counsel for the state of Ridgeway in probable cause hearings in relation to criminal arrests on or about this day?
Yes, Your Honor.
Okay. Are you well versed in the law to the sense that you can provide competent representation to the defendants that will become your clients?
Yes, Your Honor.
Are you sure?
Yeah.
Okay. I am nervous about this. State, any objection?
No.
One moment, Your Honor. The state would seek that the Sec. To be clear, has the court established through sworn, I mean through like some form of like sworn testimony or something subject to perjury, that Sniper All-Star 1 is qualified to practice in the state of Ridgeway? Like he's allowed to practice in this court?
That's up to Lady Justice if his generated bar number is acceptable.
If he has, the state would ask that the bailiff immediately detain this person for unauthorized identification as a practitioner.
I am unsure if the God 100 number issued by Lady Justice is acceptable for the legal practice or not. This court does not know.
As it is in the database, yes, it is acceptable for legal practice, and I also do not wish for the bailiff Timbo Walk to put any cuffs on me in any way or form, as I feel uncomfortable.
Oh my god, Dave, what have you done?
What kind of
Whoa.
what kind of woke lawyer did Lady Justice approve here? Good gosh. Okay, book him again, please. This yay has guy.
Your Honor, is there some way like to get like a sentencing enhancement on all the like repeated contempt of courts, or do we not have that?
15 minutes is the maximum I can give anyway, so not really.
We need legislation for like some sort of like contempt of court enhancement. Like once you do it like 20 times, it gets a little annoying.
Oh, Mr. Lady Justice is here. Can someone bring up Lady Justice to the stage?
Oh my god, Atticus Finch
Thank you.
wannabe looking ass.
Thank you, Dev, for that.
Lady Justice, can you explain to me what's if this guy is seriously duty counsel or not? Because if
gotta
he's
bring-
duty counsel, we have a problem. Because I don't think, in this court's opinion, Mr. All-Star can provide competent representation to people at all.
Also like to remind everyone that we will
I don't
be
understand why you're why.
You asked for a duty counsel. I gave you a duty counsel. You don't like it?
It's not what I had in mind when you said duty counsel. I didn't do that to end up a duty counsel. But
I mean, he's duly certified in what's the state called? What's the fucking Mayflower bullshit? Clark, yeah. He certified Clark. We do the reciprocity.
We do not have reciprocity with Clark.
We
no,
don't. I'll talk to the
we
Chief
don't.
Justice about that.
No, we are not. We are not getting reciprocity with Clark. There is no way.
Wonderful idea, Dave. You should definitely pressure Fed into doing it.
No. The
Yeah,
Clark attorneys are weird. The Clark
Yeah.
attorneys are weird. Oh no.
All right, Sniper. The court has rejected you, sir. Please step back to the galley.
The galley. You're gonna force him to cook for us?
If you ignore 1.10, what the fuck is 1.10? This is bias? Yeah, I think it is bias. Sniper, just sit in the jury box. That's fine too.
Okay. Would Lady Justice like to be duty counsel?
Fuck no, I haven't practiced law in like 3 years. My law is my ban power.
Okay. In that case, would anybody like to? I don't know.
You know, while we're at it, I still have that expungement filed.
Sure, we can do the expungement. Okay. 7 days mandatory waiting period is met. How can you show, Mr. Rummy, that you're in good standing with the community and that your traffic tickets here should be cleared?
Yes, I am a longtime employee of the Department of Justice. I abide by the law. You know, unfortunately, there's no escaping Mr. GD Steele's traffic enforcement. So So when my driving performed a little less than exemplary, let's just say that that I got some citations. But I'm a much better driver now, the best of the best, some would even say, and I'm ready to have those traffic citations expunged.
It says here that the traffic citations were issued by Officer Peak Effect of Milton Police.
Oh, sorry, I do clarify peak effect. I had awarded GDC an award, so I was confused. But yes,
Okay.
the facts remain the same. The facts remain the same.
Okay. Well, good enough. We can do that. I suppose we could grant the expungement, the traffic tickets. Let it rest. No job. I suppose we could do the traffic tickets. Okay, there we go. Ooh, all right. Is Lady Justice gonna force Clark transfers?
No.
Bro, no one's gonna tell Fed what to do, bro. That'd
Okay.
be fucking scary.
Just wanted to make sure. All right, let's check the database. Let's see how we're doing now. All right. Hey, some duty council. Anyone you like to be duty council?
If only we had a state bar Discord in the Supreme Court where all the bar certified attorneys were.
We have a channel. We just need somebody to show up.
Get Robin in here, man. Get Robin in here. I haven't gotten to litigate against Robin yet.
Get Robin in here. Let's see what Robin's doing.
Or someone grade Billy Bob the Joe's bar exam, which I doubt he's gonna pass.
Okay. Okay, let's make a couple more announcements today. Other state events going on while we wait for duty council. Just because we're waiting for duty council doesn't mean you can sit at council table. Just because you feel like it, please remove them. We have the bar exam is open. If you take the bar exam legitimately, you can become a lawyer and participate in these hearings. Let me see what else we have going on here.
Don, are you even bar certified, man?
Yeah, we do need a clerk's chair. We do need, our poor clerks have to stand up at their desk for their long hours during their trials. There's no chair for the poor clerk to sit at. I don't want to get an OSHA complaint. Yeah,
Tell
we
OSHA
want
to shove it. The Department of Public Safety approved it. OSHA can shove it.
the Department of Public Safety is forcing our hardworking judicial clerks to stand at their desk for hours and hours.
Yeah,
This
it's
is
called
all-
standing desk. It's very hip in IT.
Okay. All right. Do you have any search warrant applications, anybody? Actually, wait, we shouldn't do that in the public stage. Never mind. Let me see what we're doing. Okay. The bar exam can be found in the Supreme Court Discord for Mr. Jonathan. Yeah. I like the closed captioning on the stream. It's very cool. Very cool. Okay. Does it pick up everything I say?
Fuck. Oh, it does catch that. Nice. It's better than Teams.
Yeah.
Teams censors that.
Interesting. Okay. Well, until we have duty council coming back, would the media like to? We're gonna go and maybe we can talk a little bit about the judiciary at the what do you call it? Annex building. So, I don't know, Joseph, if you want to come with me, we're gonna go to the annex building. Until we have duty council show up. I just DM'd a couple people and see if they wanted to come, and yes, it'd be great. All right, we're gonna be going to the annex building. I'm gonna be talking about a couple opportunities within our state. Wow, look at this setup. This is wonderful. Look at that. That's beautiful. It's absolutely beautiful. Let's see if they added my picture yet. All right, we're arriving at the annex building now. Why were you banned in the first place? I can't unban you from the Supreme Court, sir. Okay. Yeah. So welcome to the government annex building. If you haven't been here before, it's a nice place to be. My office is right here on the first floor. It's the first one on the right. Let's see, I don't think they added my picture yet, but yeah, I think it would usually go on that wall. Yeah, this is a place where we usually hold some meetings. Some of which have gone well, some of which have not, but that's okay. I got a whiteboard and a filing cabinet. This is always nice. The governor also has an office, but his is upstairs. Yeah, this is where the Department of Justice spawns as well. I'm gonna be walking through here. I feel like I'm on like a documentary about my daily life now that we're not in court. Oh look, it's the governor. He's made his way over here. Oh, Mr. Governor. Dude, look at that. There's the governor. Very nice. Oh, they haven't changed the governor's portrait yet either. It's still Matrix, but that's all right. I got some. Yeah, this is the on the top floor is all the elected statewide officials. We got the Attorney General. We got Secretary of State. These pictures are the old people, but hopefully they change them soon. We got yeah. But Governor Matrix nominated me to the both court. So it's always nice to meet and hear with him when he interviewed me for my position. Before the Racine estate was built, of course. Yeah. I don't know, Mr. Governor is in the stage now.
Hello.
Hello, Mr. Governor.
Nah, the executive's encroaching on the judicial. That's
I
why.
was invited up here. I'm not sure by who.
I invited you up in case you wanted to say anything.
How's the probable cause hearings going?
They were going well. We had to put them on hold temporarily because we don't have anyone to be the defendant's lawyer. The duty counsel.
What do you need?
We need somebody who's bar certified who does not work for the Department of Justice.
I am bar certified and I do not work for the Department of Justice.
Would you like to be duty counsel?
If you take your time with me and don't, I mean, I've never really defended anybody, but I can try.
Okay. Do you feel like you could provide competent representation if need be?
Perhaps better than someone going pro-se, I guess. I mean, I'm all you
Okay.
have, no? Why doesn't
Okay.
Sure. Dave do it?
He said no. He said his power of the law comes from his ability to ban people.
Okay.
Yeah.
Fair.
I'm not an actual lawyer.
All right, Arthur, I'll give it a shot. Hopefully I don't hopefully no one goes to jail, but they probably will.
Okay. Any objections, State? State? No, you cannot be duty counsel, Jonathan. You're not certified by the bar. All right, we're going to be reconvening now. We're going to be doing. I order 2 more. Let me control cause hearings. And a couple more of these probable cause hearings with the governor as duty counsel. It's very exciting.
Anyone who is being represented by me is getting cooked. Like, sorry, you're going to jail. Just don't commit any crime for the next 20 minutes.
Oh my, the Supreme Court is in the Supreme Court orientation. How exciting is that? Thank you. Is that Oh, I'm under the map. Oh, that's cool. That's pretty interesting, actually. All right, everyone.
I'm coming, chat. 1 second.
All right, let's bring in our first criminal defendants whenever everyone gets here. But if you're a cop and you'd like to have your defendant be defended by the governor, the leader of the government that is prosecuting. Actually, no, it's not technically since it's an independent agency. But anyways,
That would be a pretty biased defense. If it was, like any other state that doesn't
all we
have
got.
an attorney general separate.
yeah, that'd be kind of nuts. But luckily we don't. So our honorable governor can defend them.
Be there in 1 second.
Quick 40-minute nap.
One sec. Hold up a sec. Yo, Vince fan.
Yeah.
Fuck you. All right, I'm done.
All right.
You were saying?
Vince Fan is duty counsel. Vince Fan will be defending people today. I'll get a couple more hearings in before we call it for now, and then maybe do some later after the Rummy report. Is that it?
These guys don't know what I'm wearing.
Oh, Dave has left, but Paul has joined. Hello, Mr. Paul.
Can we get the? Can we get the? Is there like a?
Oh, we have the lieutenant governor here as duty counsel.
Is there
Look
like
at
a
that.
sheriff's officer that can help move these criminals out of my seat, please?
We have the governor and the lieutenant governor as duty counsel. Look at that. How
You are
exciting.
discriminating against me.
Okay, can we clear the council table, please?
I
What?
don't think discrimination is a law in Ridgeway. I don't think you can.
Okay, can duty counsel please tell me what the fuck he's wearing?
I'm wearing the Crown Attorney gown from the British government.
The crown attorney gown?
Yeah,
What is a crown attorney?
it's what we have in Canada.
It's called a crown attorney?
Yeah.
This is very formal court wear, Your Honor. This is more formal than a suit.
It looks like he's some like
Your Honor, look up Crown Attorney on Google.
crown attorney. What?
Clothing.
Crown attorney. What? This is. Huh. I look up crown attorney, and the first result is Peyton P. Randolph. Oh my. Crown attorney. Look at that. That's really something. Why do the crown attorneys not just wear normal clothes?
So I don't know. You'll have to ask
Oh, here. Let me look. Yeah, look. This one.
someone.
Okay, thank you. This is quite unusual. We in America do not like crowns. We don't like monarchy. I will be ruling against you in everything you do now. I'm just kidding. Okay.
All
let's hear
right,
our first
chat.
case.
Can we get ethics?
All right. Probable cause hearings are now back in effect. Please bring your criminal defendants before me for a hearing, and we'll be able to hear what the facts of the arrest are, and then we can decide if there's probable cause or not. The last batch of hearings was very, very well done, I will say. Both Rummies did an excellent job.
I can't goon.
Who said they can't goon? Who said they can't goon? Was that you, Joseph? Who said that?
No, there's a guy in the gallery that says he can't goon.
He escorted to jail.
He's Jewish. He has a Star of David on. You can't do anything to him.
What? Okay, we will wait for some criminal defendants in the meantime.
Wait, isn't
What?
Okay. Where are these criminal defendants? Okay.
I
Where
don't
know.
are these criminal defendants?
Some people, guys.
We have no criminal defendants.
Where are the police? Can the police arrest people, please?
We really have no police here, huh? Oh, he got a gun, bro. That man's got a gun, bro.
How's everyone doing today?
I can't goon. I can't goon.
Whoever next, you can't say I can't goon in a courtroom. What?
Your Honor,
What are you
Are
gonna
we
do?
in
Hold him in
session?
contempt?
Are we in session?
they killed that man.
He'll pardon
killed-
himself.
I can do that.
Probably not.
Somebody check the const.
Did
I mean, Matrix pardoned himself, so
he?
yeah.
When?
Right before, like a few minutes before leaving office, or a few hours.
What did he even do?
That's crazy.
He didn't even commit a crime, did he?
Pardon that was like registered by the Secretary of State.
But he pardoned himself for what?
I don't fucking know. I didn't read the pardon.
Did he accept it in open court? Because if not, we should revoke that.
Are pardons revocable? Wouldn't that bring like the question of preemptive?
If he didn't accept it,
Guys, this man has a gun. Can we get police? Just do what he says, guys.
I gotta do that search warrant application for our little friend over at the DOJ. One sec.
I can't goon.
Where are criminal defendants?
There's a lot of people in game, so
there's only 2 cops and they're not here.
holy crap! There are only 2 cops. All these residents in game. Damn.
We may have to reconvene later. Oh, do the governors want to make any announcements while they're here and have some people's attention?
No.
Senate session at 8 p.m., guys.
Oh yeah, Senate session at 8. I almost forgot. Oh shit.
If
Arthur Chen is
we're
down.
criminal defendants, I think I'll go ahead and we can do that closed hearing for the search warrant I want to apply for the individual we spoke about.
Okay, we can do that.
Dave Gralius.
Is this button visible now? The change. What the heck? You can pick the change court button now. What is that? Okay. In that case, we are going to be briefly transferring over to the Palmer Police Courthouse to hear the closed search warrant hearing. Unfortunately, Mr. Crown Attorney is you look like you're wearing a bib, like it's a mix between.
Dude,
like, a
this is
priest
what
and,
they
like,
wear. I don't know why they wear it, but this is what they wear.
Oh, weird. Okay, well, whatever. That's how it is. All right, we're gonna go to the other one. And we're gonna search warrant, and then, Rummy, do you have a podcast at 11?
I have a podcast at 11. We have a podcast at 11 p.m. Eastern, which hopefully we will have the lieutenant or the governor call in.
You want
Wait.
someone from the auditor's office?
What do you want us to talk about?
Like
It'll make sense. Yeah. it'll make sense.
from at where? At the hearing?
Yeah.
Can
No,
it be us?
For
I
what?
mean, if that's what you want to send in, sure.
That's all, I mean, that's all you got, to be real.
Wait, what?
I guess we're going to the hearing, Vince. Get in the car.
What do we need the auditor for?
I don't know. Get in the car.
Put him in the loop. Because
Do not let the guy with the gun down here, bro. Oh my god. Oh
Too
my
late.
god.
This guy's shirt says real DX9 user. Where do I buy that shirt? All right, there goes your car, Walter.
That's
Good
fine.
stuff. All right, everybody get in my limo if you want to be annoying. Everybody get. Okay, we're gonna die now.
It's gonna blow. So I guess I'll just go to the Palmer Police Department.
Okay.
This is
All right.
operating an unroadworthy vehicle.
All right. I'm getting shot. Okay.
I thought you're like the president. The president's not allowed to drive.
Where's RSP though? That's the question.
Yeah, like where's my protections at, man? They really don't care about me.
I don't give a fuck. The only person who cares about me is Tactical Dank Patriot, and he's not even protections. For sure, that guy's just a regular ass trooper.
Wait, why are we here? Why don't we just do it there?
Well, the idea was so that people wouldn't follow us, but clearly that didn't work. So, oh, this one, look at this courthouse. This one has a seat for the clerk and a seat for the witness.
I've just been joined by Cardinal Montera.
Oh dear.
So why are we here?
Alright.
This is the question.
All right.
Well,
Let's
we'll move
hear
to
the application from the state.
I'm sorry, I'm still parking. Open up. I'm downstairs. Where's Arthur Shinlin? Anyone coming downstairs and open up these doors, or
This guy's lost.
This guy's in Milton. Just rejoin at that point, Joseph.
Oh god.
You gotta set your spawn point to Palmer.
Okay. Yeah. Are you locked out?
yes, I'm in the
Okay.
lobby.
Okay. Oh well, you can get here. We're in the lobby, are you?
He's not locked
Oh.
out. He's lost.
No, I'm now I'm in the back office.
What? How did you get there?
1 second, I'm being transported. Okay. We'll move to a closed VC, I guess.
Mm, if anyone wants to fill the airtime by making some inflammatory remarks, I guess we can let you up and do that. All right. Who'd like to make some inflammatory remark?
Just at the stage, bro. Just end it.
Okay.
Yeah.
All right. Thank you everyone for coming. Bye bye. Wait, how do you end a stage?
Wait, what are we doing now?
We'll set up a group chat for the
many people that were vegan and now paleo, eating like cavemen. So weird. But Los Santos is a weird place, and you love it. Just like you love all these tracks. Maybe you have to lie to yourself and say you're loving it, ironically. But hey, whatever it takes to get you through the day. Sometimes that's tofu, other times it's prehistoric bacon.